The shooting, that the internet searches were made from his...
I'm sorry, are you talking about this case or the third-party culprit evidence?
The third-party culprit evidence.
So you're talking about the events at Vevo Lounge or somewhere
That's what I've been
else?
generally or specific. If you're talking about the prior bad acts or subsequent bad acts, are we limiting to that, Your Honor?
Yes.
Oh, yes, so absolutely. So with the Vevo shooting, so specifically, we intend to go into the facts of the Vevo shooting as sufficiently related to our theory of Mr. Bradley as the third-party culprit. And the similarities are these, Your Honor. First, it was an argument in a nightclub involving Mr. Bradley. Mr. Bradley getting angry at the nightclub. Mr. Bradley retrieving a gun from his vehicle. And Mr. Bradley...
Well, he'd been shot, hadn't he?
Yes.
So let's go through the facts that you would intend to elicit. Or do you intend to omit the fact that he had been shot?
No, that is a fact.
Okay.
That would definitely...
So we have an argument at a nightclub.
Yes.
And do you intend to elicit the details of that argument? What precipitated it? Who involved? Anything of that sort?
To the extent we can develop it, yes, Your Honor.
Well, what would you show?
We would show that he got into, at a minimum, we would show he got into an argument. I'm not prepared to represent exactly what he was arguing about.
You mean you don't know?
Right. Presumably it will come out on cross-examination. So if that came out, that is appropriate. But the fact that he was in an argument, we think is relevant. The fact that he kept a gun, a firearm in his vehicle is both relevant and similar. The fact that a response or the response to the argument was going to the car, retrieving the gun, and eventually using that gun is both relevant and similar. And so we would elicit all of those facts, the facts of that evening, as evidence that Mr. Bradley is the third-party culprit. And one additional fact, of course, that the firearm that he retrieved was a Smith & Wesson revolver, the same sort that is at issue here.
In caliber?
40, I believe, Your Honor.
A Smith & Wesson 40 caliber.
Yeah, I can check on the caliber.
Well, that's important here.
Semi-automatic.
Smith & Wesson, maybe. Court's in motion. Right, so we do know that it's a 40 caliber because it was used in another nightclub shooting. 40 caliber Smith & Wesson pistol. And indeed, and we have a serial number because that gun is connected with another shooting, of the Bridgeport shooting, which we mentioned in the hearing back in February 28th.
Okay.
And the shell casings matched with the, excuse me, Your Honor. I guess the one more similarity that I would add is the shooting at multiple people, which is similar to the case in Barr, which 2 people died, but multiple people were shot at. There were apparently
All right, what are you
several
talking about now? Are you talking about Bridgeport or Vevo?
Still talking about Vevo, Your Honor. Vevo, there were multiple people inside the club where Mr. Bradley shot.
Well, Mr. Bradley was not inside the club, though.
He was outside the club.
So
shooting.
what happened there? Was it shooting through doors, windows, walls?
Indeed, shot at the door initially,
Yeah.
couldn't get in, and then shot through glass or window portions of the club. And from what we understand, there were, several near misses with respect to that shooting. And the law of third-party culprit evidence, Your Honor, as Your Honor knows and as Your Honor indicated in the February hearing, only requires us to show that there is that this a theory of the case or that the evidence is not too remote or speculative.
Well, it must have substantial probative value and a rational tendency to prove an issue in this case. So speak to that if you would.
So the substantial probative value
Yeah.
is that it tends to show that Mr. Bradley has this modus operandi, if you will, that he has this technique, a very identifiable technique of responding to activity or confrontations inside of a club. That indeed Mr. Bradley is the individual who responds to this sort of impetus, that responds to the confrontations in a club by gun violence. That Mr. Bradley is the one who stores guns in his vehicle and has them at the ready when he is indeed going to a club and going out. That it's not Mr. Hernandez, the one doing this, but rather this is Mr. Bradley's signature. To the extent that relevant and probative evidence is evidence that tends to move the probabilities even slightly with respect to the existence of some material fact, it is clear to our thinking that Mr. Bradley, that this conduct of Mr. Bradley is sufficiently close in kind and behavior to fall within the standard that you articulated, and that is not too remote or speculative as the courts have said. And indeed, in Your Honor's first look at this in February, Your Honor even came to the same conclusion that these had sufficient similarities to at least surmount that initial hurdle of it being probative of some material fact in the case.
Well, certainly the fact that the defendant was involved in a shooting for which he was then charged and for which he ultimately pled guilty and was sentenced is relevant. And that's admissible by statute as impeachment information.
Yes.
And all the various convictions arising from that incident, including reckless endangerment and criminal mischief,
Yes.
would be admissible. Now, you would intend to present this evidence in what form? Simply through cross-examination? Would you be calling witnesses who were present at the Vevo lounge? Would you call police officers? How would you prove this?
Well, we would do it through cross-examination. Now, obviously, if the witness agrees with the assertion put forward on cross-examination, then we have no...
And the cross-examination would be of what form? Simply asking him questions?
Simply asking...
Did you in fact
about,
do
did you
X,
do
Y,
this?
and Z?
What, did you do that, et cetera?
Yeah.
Obviously, if he denies that, and should we need to complete an impeachment, then we could bring other witnesses to complete the impeachment. But as an initial matter, we certainly would put the questions to Mr. Bradley. If he answers those questions honestly, then there may not be a need for additional witnesses. It's hard for me to say ex ante what he's going to do.
Well, assume that you did have to impeach him. Are those the new witnesses you added to your witness list? There were 5 or 6 or 7 names not previously disclosed. Would they be the club participants?
Yes.
Or people? So they're already named and
Yes.
they're listed.
Correct.
Okay.
Correct. And again, this would be brief and contained, Your Honor. We certainly understand the courts generally reluctance to have trials within trials and many trials and so forth. So this would be contained to a specific set of facts that show that this particular witness, who is a third-party culprit, is more likely to have engaged in this conduct that the government is alleging that Mr. Hernandez engaged in. One point I would make, Your Honor, with respect to third-party culprit evidence, is that the baseline for third-party culprit evidence cannot be whatever the government's theory of the case is. If that is if that is the case, then it would swallow up the law of third-party culprit.
Because the Commonwealth isn't contending there's any third-party culprit.
Exactly. So our theory necessarily differs from the government's theory, and there's certainly more than enough evidence to put us in third-party culprit territory. And as the court knows, the ability to cross-examine a third-party culprit witness may raise issues that reach constitutional dimensions. Because of Mr. Hernandez's rights to put on a third-party culprit defense, that is not in name only. There has to be some substance behind it. And the substance behind it, as Your Honor has articulated, is whether we can offer something probative. And these similarities, just on their face, argument in the club, gun in the car, go get a gun, use gun to vindicate argument in a club. I mean, these are the very sorts of similarities that the law of Massachusetts, as it sets out third-party culprit evidence, permits. And then there's a wide range of cases across the country. They usually come under the banner of third-party perpetrator, but they say the same thing. As long as you can show a nexus between the conduct of the third-party culprit and the allegations in the instant case, it's the sort of thing where, as Massachusetts courts say, everything, all has to be resolved in the defendant's favor. Otherwise, we risk constitutional injury.
Okay. Anything further?
So with respect to, that was with the Vevo, and with respect to, there was also a Bridgeport shooting where the cases match, the casings match this same gun from the Vevo shooting. The Bridgeport shooting was March 23rd, 2013. Even closer in time, though that's not a dispositive issue, even closer in time than the Vevo shooting. We would certainly want to inquire whether he used that firearm, and I'll say I'll say pistol, to ensure I'm using the correct terminology, whether he used that pistol in that shooting as well.
And what do we know about that incident?
Well, this
Are there any police reports on that incident?
We do have police reports on that instance. I don't know if Your Honor has seen them.
No, I haven't. How would I see them?
Just with respect to the voluminous, some of the voluminous motions and discovery that have gone on, we can provide them to you. I'm holding in my hand now a report that shows the ballistic match.
Yeah, I'm told there's a ballistics match.
And-
I haven't been told there's any other connecting link of any kind except for a match between .40 caliber Smith & Wessons. It would be helpful, I suppose, to see any reports that may exist on that.
Right. I have reports I can pass them
Why
along
don't you hand them up?
to the clerk, as well as the ballistics match. You guys have this, right? Connecticut report. Asked based on a video.
Thank you.
So here, Your Honor, our submission is that this is relevant evidence that would not tend to prejudice or confuse the jury in any way, because it will be limited and directed to Mr. Bradley's activity on particular days, particular evenings, early mornings, if you will, and will be limited in scope and direction, but it is Mr. Hernandez's constitutional right to admit evidence of that tends to show that the third-party culprit had the opportunity and motive to commit this crime. And this form of evidence, again, shows that Mr. Bradley had engaged in this sort of criminal behavior in form similar to how the Commonwealth alleges the event happened back in July of 2012. And it's the informed similar that we think is the gravamen of the argument. And so long as we can make out that there is a nexus, connecting link, to use your Honor's phrase, then that is sufficient as an evidentiary matter for the jury to hear it, and the limited scope cures any potential for prejudice to the Commonwealth or confusion of the jury.
Okay. Anything further?
Okay, the government has this as well. I'm passing up, this was part of our initial motion. This is the 2006 narcotics report. The only other thing I would add, Your Honor, we would intend to, I'm speaking with respect to the Vevo lounge, we would intend to confront Mr. Bradley with the video evidence of the shooting as part of our cross-examination of him.
How?
We've got video.
I'm sure you do.
Yes.
How would you present that?
Is this you shooting in the course of cross-examination?
What is it doing? Is it impeaching him? You said that you would ask tightly controlled questions of him, limiting the scope of them to the similarities.
Right, and indeed.
Now playing a video sounds to me substantially different.
I think we can ask run-of-the-mill cross-examination questions based on a video. We've been doing it all trial on cross-examination
Okay.
with witnesses with videos. So again, this would be nothing outside of the ordinary. It will be tightly controlled.
Tightly controlled video? Meaning what? You've edited it, or
No, it
you're
would
just going to
only-
hit play?
Only ask, we'd only show the relevant portions of the video. Ask the witness, this is him, this is you engaging in Act A or Act B or Act C. It's not going to be, if Your Honor's worried it's going to be movie time, that would not be our intent. And we'd be happy to make a more detailed proffer about how we would use the video, but I can represent that it would be a very tight.
Is the video on a thumb drive? Is that something I could see?
Yes. Oh, yes, absolutely. Do we have?
Could you give me a thumb drive that actually contains this video?
Absolutely. We are getting it right now.
All right, Mr. Sullivan, I can receive the video and look at that. Are there any other arguments?
Okay.
Are there any other arguments you wish to make in this regard?
No, Your Honor. Approach sidebar on this, very briefly on this thumb drive.
I'm sorry, the witness was convicted, are admissible. One of the offenses is unlawful possession of a firearm. And to the extent the Connecticut law relates to unlawful possession of a firearm in public or in a public arena, that element could be listed, as well as at least the allegations underlying reckless endangerment. As to extended details underlying the Vevo incident, the defense is correct in suggesting that the third-party culprit doctrine is of constitutional significance. It is constitutionally based, and where there is any close call, the courts have told us that all doubt should be resolved in favor of admissibility of third-party culprit evidence. But that evidence is, as the many cases have told us, not without limits. The evidence sought to be presented must have, quote, substantial probative value, being a rational tendency to prove an issue in the case, and will not tend to prejudice or confuse the jury. As the courts have told us, so-called feeble third-party culprit evidence should not be presented because it has a risk of unfair prejudice to the Commonwealth, in that it inevitably diverts jurors' attention away from the defendant and from the facts of the charged offense. I have taken time to look at the cases. Mr. Sullivan has argued that evidence of the Vevo shooting may be relevant to show motive or opportunity. Frankly, I don't see either motive or opportunity to be demonstrated by the like conduct or the alleged like conduct in Connecticut relating to shooting at the Vevo lounge. The question then is whether or not getting into the particulars of that incident would tend to prejudice or confuse the jury in this case. I'm considering whether or not the facts of the Vevo shooting, so-called, are so singular or of such striking resemblance that we might consider it a common course of conduct or a pattern of conduct, or almost a signature crime. And I will look at the video as I consider that. I do note that the Vevo shooting is quite remote in time, some 19 months after the offense here. And I think if the jury were to view video, that might have, well, it would have a prejudicial effect on the Commonwealth, but it might simply confuse and divert the jury's attention. As to the Bridgeport shooting, I will read the reports, but a mere connection of this firearm from the Vevo case to a Bridgeport shooting without any more likely is insufficient to demonstrate that the witness, Mr. Bradley, had any direct involvement in the Bridgeport shooting, such that that conduct would be admissible as third-party culprit evidence. So I'll look at the reports and the video that I submitted this afternoon, and will rule in the morning as to whether or not the particular facts underlying the convictions that Mr. Bradley is now serving a sentence for will be admitted. But again, the fact of conviction is admissible. And this may be a situation where I have to listen quite carefully to the questions put to the witness and his answers to see whether or not it is appropriate to admit evidence that otherwise might be remote or might be prejudicial. Depends in part on what Mr. Bradley says during other questions put to him. All right, Ms. Medina, if you would, when you have that thumb drive, give it to Mr. Sheehan, and we'll be in recess. Mr. Sheehan, and we'll be in recess.